This is attorney Chris Steffen, and this is How to Defend Yourself in Eviction, Part 2. So at this point, you've received your UD 100 unlawful detainer complaint, and you know that from the moment that gets over to you, you have 5 days to respond with your answer to the unlawful detainer. If you don't do that, you are very likely to be evicted from the unit that you're living in. Now, you may be saying to yourself, but wait, don't they have to personally serve me? And if they can't personally serve me, I get more time. I've seen tenants take this to extreme lengths where they're basically hiding and avoiding potential process servers. I've even had one tenant who literally ran for their life when somebody identified themselves as a process server. This is all incredibly unnecessary and, in fact, harmful because that's not the standard. In the state of California, in unlawful detainers, we have something called constructive notice. Constructive notice is pretty simple. The court will want to know, did you know that they filed an eviction against you? If the answer is yes, then the clock starts ticking from that date. So you may ask yourself, well, what else can you do legally to extend the clock? One of the things that's commonly tried is the use of something called a demur, where you're challenging the claims that they're making on a pleading basis. This is something that individuals really shouldn't do without the assistance of an attorney. And usually it's a waste of time in unlawful detainers. Most judges will deny those demurs and be very angry about it. Once they're denied, you have 5 days again to file an answer to the underlying complaint. Now, let's say you met that deadline. So you have preserved your rights and the case is moving forward. Well, the next step you're likely to get to is discovery. The landlord's attorney is likely to send you this, which is form interrogatories, where they're going to ask for a number of questions about you, primarily identification, making sure you are, in fact, who you say you are. The next will be request for admissions, and that's where they're going to ask you very simple things such as admit that you didn't pay the rent, or that you have a pet tiger, or that you threw wild parties that are disturbing people. The next thing you're likely to see is request for production of documents. And this is where they're going to ask you to provide the evidence that you're going to want to be able to show the judge. You have to provide it to them first if they ask for it. Otherwise, you can't present it later. Now, the thing that sucks is that you only have 5 days to provide this, and they can propound all three documents on you at the exact same time. If you do not respond in time, you just forfeit and lose. Again, this is a point where you may want to talk to an attorney, even in limited scope, just simply to get the help you need. Here's a link to a sample response form that you can use if you're going to do this on your own. Now, do remember that just because they're asking you questions, you also have the right to ask them questions. And a lot of times you can really perplex counsel for landlords when you propound discovery on them. Once that happens, you and the landlord are essentially in a staring contest as you prepare and get closer to trial, which we're going to talk about in the next episode.